Hello, everyone. Thank you for having us, first of all. And we hope you've had a lovely evening yesterday. It was packed yesterday from where we were standing. It was full. Is it okay now? Yeah? Okay. I was just following the guidelines. So anyways, yes, my name is Monika Górska.
My name is Lena Marcinoska-Boulange. Thank you for coming. It's a pleasure to be here again. So, guys, AI is something that, it's rapidly growth in the recent months, and we prepared for you some, let's say, tips, legal tips. We've prepared 4 legal issues that we would like to discuss with you and make you aware of, because AI it makes life easier. It accelerates various processes, but it also causes challenges. I think that most probably it causes more than it solves.
And we will talk about legal AI, so the legal aspect of AI. Unfortunately, we will not have time to discuss ethical and philosophical and all the other aspects of AI, which are tremendously interesting. So bear with us. We'll try to make it not very legal, but hopefully we'll share some legal perspective concerning AI.
But before we start, we would like to ask you some questions that will help us to, understand maybe your questions afterwards better. So in general, do you use AI? No, not necessarily for work, just for fun, for some testing.
By show of hands, who is using AI?
Oh, perfect.
Okay, are you using AI at work and for work? That's important. Okay, so less, half and half.
Yeah. The next question, is AI likely to take your job? No, not necessarily yours, but maybe your junior colleagues, anybody in industry. Who believes in that?
Okay.
Okay.
So to clear the question you've been all asking yourselves about, we asked AI about whether AI will kill lawyers' legal jobs, and he said no, so yay for us. But moving to the next question, is AI likely to kill your creativity?
Who agree with that? No?
No show of hands, so okay.
Okay, and the last question, is AI likely to deprive you of your IP is intellectual property rights. So who believes that it will deprive you of those rights? Okay, that's good to know.
Okay. So moving on now to some legal stuff. So yes, AI is obviously a very hot topic at the moment. And people are excited about AI, about using AI, but also what the AI will do to the industry, and not only game dev, but to the industry in a more general sense. But it's also making people a bit upset and angry, to put it mildly. So this is just to illustrate how people, at least some people, approach the subject of AI. We chose to ask a question: has AI been stealing your work? Because we should probably start, when discussing legal aspects of AI, we should start with the beginnings of AI, in a sense. How come generative AI can, produce output? Well, there must have been some sort of input first for the AI to produce anything. So, Did it steal? Well, to some extent, steal is maybe a very strong word, but obviously the AI, the machine devices, whatever you call it, have been collecting data from the internet. Now, how is it possible that they do it? That's for you, probably you're better equipped to understand that and explain. But people have been putting stuff and data and information on the internet quite freely since the beginning of the internet, right? So, we do have all those websites, YouTubes, Facebook, whatever, that's packed with data. Some of that data, some of that information, some of those works there, they're not protected by law, because they're just snippets of unprotected information. So the AI could, or the systems behind AI could easily and legally collect that information. Some information is in public domain, which means it's no longer protected. It was protected. Copyright, for example, copyrightable works are protected throughout the life of the author and then 70 years after he's dead. So some of the works are already in public domain. That's fine. AI can do whatever they want with it. But obviously there's a massive bulk of data, of information, of works that are still protected to some extent. And here is where the problem starts. So we know already about 2 lawsuits against major AI systems, the OpenAI and Midjourney. The OpenAI thing is, I don't know if you're familiar with the OpenAI. What's been very interesting to me is that the lawsuit, and I know that it's the 2 or 3 days ago there was information that this particular lawsuit is going to trial, so it's not dismissed. It will be tried in the U.S. court. What's interesting to me is that the core of the lawsuit is not really about copying. It's not copying software. It's not copying source code, because the lawsuit was about source code that was, let's say, collected by the EI and then used in ChatGPT. But it was not about copying. Copying is just one of the arguments. The main argument of the lawsuit is that, and you probably know it better than I, that source code was published on GitHub, but with specific attribution rights and license rights and license terms. And the core argument is that OpenAI, when collecting source code, when kind of retrieving the source code from GitHub, is not equipped, is not trained, it's not possible for OpenAI to collect also information about authors and about the terms of license. And that's one of the main arguments that they are raising in the lawsuit. The other one is breach of contract, and which means breach of the terms of license. So yeah.
But the other lawsuit that was filed was this one against Midjourney. It was not about, like Monika said, attribution or like contract, breach of contract, but it was about just copying some pictures, artistic work from websites, and some group of artists were just, not happy because of that, and I can imagine that they really could, because they were not remunerated for, taking those pictures by AI. So they also filed some kind of lawsuit against Midjourney. But I think that it was maybe a few days ago, but this lawsuit was dismissed already. So unfortunately, it would be very interesting to know what would happen, but maybe there will, other lawsuit will be filed.
So we're looking for GitHub for the OpenAI lawsuit. We'll see what it is. How was it possible, and why it's, let's say, a gray area? So the collecting of information, collecting of data is, in legal terms, it's called text and data mining or web scraping. And in the US, it's been always a gray area. It was not regulated in any way. And to some extent, it was considered fair use. Now, I do understand and I appreciate that gaming is a global phenomenon, but unfortunately law is very territorial. So whatever happens in the US, it could be a very nice indication how to approach such an issue, but it will not affect and influence EU laws and EU countries, because the copyright law is a territorial law, so each EU country has its own take on it, even though there are certain areas which were either harmonized or unified. So anyway, so the US, they approached the text and data mining problem as a fair use doctrine, specifically when it's used for a greater good, so where there's an explanation why you take the snippets of someone's copyrightable work. So, and that, let's say, rule was partially established in the Google trial. If you recall, Google was the first, let's say, web search engine that scanned books and made them available on the internet. in the EU or in Europe in general, in Poland, the web scraping, text and data mining was not regulated until the EU decided to introduce Digital Service Market Directive. That's a very important directive, not only because of text and data mining, it's that there are also provisions that will concern and will affect directly gaming industry. But there, the EU realized, oh, data information, that's the new oil, that's the new gold, that's the new, revolution. So to some extent, we need to balance to make data and information available, but also to allow people to say, well, maybe I'm not interested in just giving up my data, my information. And therefore, there is an exception.
But this exception provides that that AI and other tools can like go through the website and scrap information and your pictures that are accessible online. So this is this exception, right? But if you don't like that, for example, you are an artist, right? At least in Europe, you can say, no, I don't agree to that. You can opt out from that. So maybe you heard about that, but there are already some platforms. For example, Have I Been Trained? This is some kind of website. You can sign in and you can just find, it is a tool that helps you to say no, for example, to AI tools that are going through the website and scrapping information. But you don't necessarily need to have, specific website, but you can just, for example, in your privacy policy, for example, if you are an artist and got your portfolio online, you can, in the policy, write something like, no, I do not agree. And you can do the same using some technical tools. For example, put that information in some kind of software or data that is readable for scrapping machine, let's say.
And we did put litigate with a question mark because obviously the state of courts in each jurisdiction varies. And as I said, again, what will stick in the US court not necessarily will fly in the European National Court. Because it is to some extent a grey area, litigation is never excluded. One reservation I need to make, the text and data mining provisions are in the directive, as I said, Digital Service Market. Directive means that it has to be implemented into national laws, and that's a process that takes time. Poland has not yet implemented the directive. So some countries, they already have those provisions, they already have the exceptions, there you can opt out. Poland has not changed the copyright yet. So there is a directive that works on amendments to copyright law, but that has not been yet passed.
So I think that the most important information for you is that you can take like informed choice. So you can opt out from this possibility to mine your data.
Okay, so next question. How would you answer this? What do you think? Do you think the output from AI is protected in law? It's public. Yeah, which is, we'll discuss it. Anyone else? Any thoughts? Protected, not protected? Haven't decided yet.
Okay, so the other issue, very important, I would say that the most important is that do you have copyrights to the output that is given to you by AI tools? And the answer is no, because this output is not protected by copyright, at least now. So be careful, because it means for you that if you generate something using AI, it means that it is free, it is in public domain. Everyone can use it, right? So if you create, I don't know, for example, a character for the game, it can appear, anybody can use it, and it can appear in other games, on t-shirts, on caps, whatever.
Yes, exactly. So the question is why it's not protected in law? Why is it not copyrightable work? And I would argue that this question is very valid and difficult to answer, because if you look at the copyrightable work or the definition of a copyrightable work, not in every jurisdiction you will find reference to human or, direct input that a copyrightable work must be created by a human being. It's very hard to find this human element in the text of a definition. However, this is how we approach copyright in a general. So copyrightable work is a work created by a human being. So that's why there were those cases, media cases about can a monkey be an author of a photograph and everything. And that also, to some extent, that applies by extension to AI, because the output is, let's say, created by AI. It's not created by a human being. Then it's, at least for now, it's not considered a copyrightable work.
So what you should be aware of is that AI and these tools are not a tool like, for example, this traditional one, like a hammer, like a camera, and so on. When Monika and we asked ChatGPT, will you kill creativity or something like that? He answered, no, I am just a tool. I can only assist you in blah, blah, blah. But, this is not this kind of tool as this kind of tools like traditional ones. So, because if you use a hammer, at the end of the day, you receive some, let's say, a sculpture. If you use a camera, you receive a picture and you are the author. You've got copyrights to those things. But if you use AI tools, you will not have copyright to the output.
I see questions. Can we just agree that we will take questions at the end, because maybe we'll answer your questions throughout.
And one more thing, this is something that is like it exists. It's confirmed in Europe, in European Union countries, but also in US. But very recently, US office issued some kind of guidelines that is very helpful to understand how AI output works. And US office says that because probably you know that in US copyrights can be registered. In Europe, we do not have such a system. We do not register copyright, but in US, you can register your copyright. So if you want to do it, now US office will ask you whether this work that you want to register was created and in what part by AI.
So how to make it more human? You have to amend the output. So, whatever comes out of the AI, whatever picture comes out from the AI, you can add something, you can modify it, you can maybe change colors, maybe change perspective, maybe recreate something. The more you add, the more it's likely that you are getting a copyrightable work at the end of your process, because that would be perceived as this human input and your creativity on top of something that was produced by a machine.
Exactly. But be careful with that, because Monika said that if you ask some, let's say, human components, you can receive like copyrightable work. But be careful with that, because let's say that this is the picture that was generated by AI, and you would like to change something. For example, change this bubble, helmet and this hamburger, right? So if you change those things, those parts of the pictures, you put your creativity only in those parts, but not to the whole picture, right? So it also causes very important consequences, because your protection is limited only to the parts that you've changed, right? So, for example, if somebody else take the other parts that you've not changed, it is not an infringement.
Exactly, and so Lena told you about the US guidelines that suggest or kindly request that an AI work, an AI-based work be, noted as an AI work. At the moment in the EU, we don't have such guidelines. I'm not aware of such guidelines, but maybe it's just a matter of time. However, there is an AI Act, AI regulation that's been proposed by the Parliament. There's no direct obligation to mark AI work as this is my work and the AI work. But again, it could be that whenever you put such an output into the big wide world, you'll be obliged to, not only put your name, but also add that it was created in, I wanted to say co-authorship, but that's the problem. The AI is not considered an author. So that could be, we'll see how it develops, because in fact that could, from an infringement perspective or litigation perspective, just marking your work, Monika Górska and AI, that limits my rights already, as Lena explained, because I would then have to show what was my creativity and what's protected and what's free to use for everyone. So we'll see whether that will apply to the EU or whether it will be adapted in the EU.
So if the output is not protected, maybe something is protected.
Yes, and that's a thing that Lena AI, we disagreed a bit on this part, and that's why this is the question also to you, and we would love to discuss this, because where lies the creativity? If the consensus is that it's not the output because it's the machine that does creativity or statistical outcome, so where does the creativity lie? Does it lie in the prompt, in the way you write it? How detailed is your prompt? How you phrase your prompt? Because I think it's all about phrasing. What sort of words you use? What kind of descriptions you use? And we already know that prompt engineer is the most sought after position, and skills. So if there are prompt engineers, just hand in your CVs or send out your CVs, because apparently the salary is wow. So anyways, but so definitely there are some skills. There's something about this prompt, but is it a right? What is it? Do you own the prompt? Is prompt protected? Can we move the IP to prompt rather than to the output? And so we discussed this, as I said, Lena and I. So we came up with two. Either prompt is just skills and knowledge, which is not really protected. It's something that you learn. And if you're a master in prompting, that's great, that's good for you, but you don't have any exclusive rights about it. And you can't say, oh, don't use my prompt because that's my exclusive right, that's my copyrightable work. We did talk about know-how, but know-how is something that is freely used to describe skills and experience. But in law, for something to be a know-how, it has to be secret, so you can't share it with anyone. So the method of writing a script, you should not share it with anyone for it to remain a know-how. However, apparently, there are already bots and devices that can kind of track down and extract the philosophy, the algorithm of writing a prompt. You can't really see that, but on the other side, there's that maybe the prompt is the copyrightable work. Maybe that's the exclusive right, which would mean that if someone copies your prompt word by word, then you can sue them or sue that person. We don't know. I don't have the answer.
So because we do not know yet, it is like for you, the advice is to have your unique style in prompting. So the selection of words and, for example, maybe the time, it is like, could be a different kind of rights, but the selection of words, some kind of uniqueness in your prompting could be protected. We cannot exclude that it will be, for example, as Monika said, a copyright or maybe a know-how, but in this part I, for example, do not agree. But this is something to have in your mind. And another thing, but it is not related with protection of prompts, but rather like what you do when you're prompting. Please do not prompt confidential information. Do not, for example, prompt, I don't know, names of the characters if you are before release of the game, right? Please also note that most probably most of you you've got some kind of contracts with game dev studio in which there is some kind of confidentiality clause, most probably under penalty clause, and just make this information public could be like harmful for the game studio.
Exactly. We know that most, not only game studios, but any businesses that use AI resources have already placed or are about to place policies on the use of AI because of those confidentiality risks. But also, obviously, and maybe you checked this or tested it yourself, AI lies. It's not very accurate sometimes. It misleads you into believing that there are this, case law, for example, and when you check this, it's non-existent. So for those of you who had game dev studios, maybe this is the moment to introduce policies on how to use AI. Also, maybe specific provisions on how to use AI should be in employment or B2B contracts. Again, to make it more, to make an internal policy logic on who can use it, whether there are any checks and balances, what you have to, maybe you have to, I don't know, save your prompt for someone to check it or something, just because as we underlined, I think, the outcome is not protected, which could have a great impact on your work. And the other thing is that obviously you're using devices, you're using AI software or whatever. You should definitely look into terms and conditions. Now, we know people don't read it. We don't sometimes read it as lawyers. It's boring, it's long, it's sometimes very, very difficult. And believe us, we had a very nice exchange with, there was Adobe, it was not actually AI device, but anyways, they used, there was supposed to be legal terms and we understood it differently, they understood it differently. So, however, it's worth sometimes to read it to know whether the output generated by AI can be used at all for commercial purposes, for non-commercial purposes, or maybe there are some restrictions. Maybe you can use it only, for a very specific reason, and the one that you kind of foresee is not covered by the license. And I do understand that people think, oh, if I breach the license or if I infringe a license, what they can do about it. Well, there's the litigate part always, hanging somewhere. So I wouldn't excuse it as such. So maybe consider also checking the licensing agreements or the terms and conditions of the AI device that is being used.
And the next issue that could be problematic, but okay, the first thing is a question to you. Do you think that those pictures could be deemed to be an infringement of somebody's rights? Who believes in that?
Does it resemble anything?
Not many voices. Sorry? Okay, so... Yeah, so Lego minifigure, yeah, exactly. So to explain, Lego minifigure is protected by both by copyright and also as a 3D shape trademark. So Monika and I, we asked some AI, one of AI tool to prepare something like that, and you use the prompt yellow brick toy figure, right? So we didn't
That's the exact prompt, okay? So we didn't add anything before or after. That's the exact prompt.
So we didn't add, brand name or something like that, and we received this figure. And I'm pretty sure that Lego will deem it to be infringement, even if not of its trademark, for sure of its copyright to this Lego minifigure. So if you'd like to disseminate that, right? So if you want to put it in the game, even as in some secondary role, it could be deemed to be an infringement. So let's be practical. I know that we all know probably that under copyright law, mere reproducing is an infringement, but frankly speaking, your responsibility will appear most probably when you disseminate that, when you make it public, and so on. So be careful. The thing is that Lego minifigure is quite well known, right? So it's rather easy to see a red line in your head and think, okay, maybe something is wrong here or can go wrong here, but there are millions of work that are not so well known, but still they are protected by copyrights.
We asked him about luxury car, and he returned Porsche and cars resembling Rolls-Royce and Bentley. So beware.
Yeah, so how to deal with that? First, of course, avoid using brand names or similar names, but be careful also if you do not use them, because as you can see on this example of this figure, even without using brand names, you can receive, let's say, risky results. And of course, the same with resembling people. People images are also protected by copyrights. In some jurisdictions, they can be also moral rights. So do not, this. You can, of course, do it for yourself, but do not disseminate that.
And also beware of that, the fact that AI has mined whatever is on the internet. The AI does not discriminate whether it's copyrightable or not. The AI has kind of collected it. So you could come across laws of panorama and the fact that there is the AI has created a statue resembling, an Italian building, and you'll be in trouble because Italy has a very restrictive laws of panorama, and not everything that is public and a building you can use. And so that all leads us to the point, make your own clearance. So if you do want to use AI because it helps your work, because it speeds up your work, then you have to put that additional part, first of all, maybe human element, but also this legal clearance to be sure that you're not liable, because in court, for the claimant, it will not be an argument. The claimant, the plaintiff, will sue you because you are infringing either copyrights, trademark, design rights. It's quite complex.
Yeah, and the level of creativity that is needed to have a copyrightable work is rather low. So you can be pretty sure that almost all just works that are somewhere are protected. So be careful.
Okay, so to finish off, that's a takeaway. Obviously, all those issues that we discussed, that could be a separate lecture, and a dive in would probably be necessary. But I think the question is easy and the answer is easy. I mean, if you use it just to speed up your work and to help you, to assist you, that's fine. But be aware of the fact that the output is not protected by any rights at the moment. No copyright, no IP rights. If you change it, if you make creative changes, if you reshape it, maybe you will end up with with copyrightable work, but then your protection, your rights are very, very limited. That's only limited to the human component.
Yeah, and I think that Monika said is the most important for you, and that you would like to discuss it afterwards. But also remember about this, the second and third point. So do not insert sensitive information, and have reasonable policies on how to use AI. Maybe add something to the contract if you are game dev studio. We already add some. We've been adding some, for example, since years, provisions about copyleft software. So why not to add something about AI also?
And our presentation was human and AI, because that was the big reveal that was supposed to happen. So we will be happy to now take questions, and we have another AI.
Yeah.
See you tonight at the after party, or tomorrow during the day, or today. So anyways, if you have any questions, then we'll be happy to answer.
Did you already come across such a case of a video game or another digital product where AI was used as a tool as an element, but also with human input. And there was some litigation, someone sued it, there were some IP problems with the product, a commercial product.
I'm not aware, to be honest, I'm not aware of a game of a game that in a scenario that you described. But you know, this could be just a matter of time, or whether or not someone wants to litigate in a court, right? It's not, but I don't know if that came across, clear enough. When you're using AI, you're not protected. I can copy your game. There's already, copycats of games, plenty. So I can even more freely.
Can you copy my game, or can you only copy the characters that were AI
Okay,
generated?
I can copy a character. I can take characteristic bits that are AI made, AI produced, and then take it into my game. So obviously, there's always a balance. Maybe your industry will embrace AI and will not litigate. That's fine. That's also fine. But at least there is the risk and
it's also another topic. In like 5 years, will there be software to tell 100% if it's AI generated or not? Right now it's possible, but in 5 years.
True, but I guess at least this is what we've read, that and to put it in a business terms, if there is an AI device, there will be the detect AI, right? So the money will flow either this way or that way, because the industry will also, not only the gaming industry or game dev industry, but the use of AI will, if it becomes predominant, then we will also need to have checks and balances. And already the EU is sort of leading the way. And
I just wanted to add that I think that also legislation goes that directive, because you will have, for example, in US, the office right now implemented this obligation to reveal whether AI created some part of the work, right? And I think that the EU will have the same rules.
Hi, thanks for the talk, very interesting topic. Yeah, myself, I work in AI, but we build AI voices for video games, voice tune AI. Yeah, so I kind of, about your last remark that not be able, everyone can copy what is produced by AI, but I don't think it's always that the case. For example, in our case, we build AI voices, but we have rights from voice actors to use those voices, and we can give exclusive rights for the developers of the game to use those voices in their game. So they have exclusivity. So there's like a pipeline in which, so that's depends on AI tool that's used, but might not be always necessarily the case that you don't have the rights, because if the provider of the AI owns those rights, the performance rights and creativity rights, they can also kind of transfer those rights to the developer. Yeah.
True, but you have rights on the input, whatever you use for the AI operated device, let's call it. There's no copyright on the output, because
there is, because the voice will sound like the voice actor. It learned from the performance of the voice actor. So it doesn't do anything different.
Oh, so he doesn't much. He doesn't change anything. He just uses the voice.
It's generative AI, so it will sound like that person, and it will learn how they perform. So it's not going to sound like something completely different. Yeah.
Okay.
So it's kind of constrained, that specific spec.
I thought that it matches, for example, different voices of different people, and then you have like a mixture of, I don't know, Javier Bardem and Brad Pitt at the outset. So
yeah, you can just use a specific data set from given voice, so that it doesn't. You are to ensure that it just gives that output that you have the rights over.
Well, I think you guys know better. As I said before, where's money in the AI, there will be money in the AI devices, either to counteract AI or to help the AI, or to produce customized and tailor-made AI, tools and solutions for industry or whatever, and they'll be more or less regulated. At the moment, this is a bit of a gray area. And because it's coming from the US, I mean, at least the majority of AI tools are coming at the moment from the US. US has a totally different approach to copyright than the EU. So, whatever is applicable there, not necessarily here.
If I had a short question, sort of in the same ballpark as here, do the whole idea, the dynamics of the copyrightability of output of generative AI changes when we are owners of the training data supplied to the AI?
No, unfortunately, no. Even if you train it using your own data, even if you have your, I don't know, closed AI, it does not change this result. The output is not protected.
It's still public.
Still.
That's why we asked you the question. Maybe the law, maybe the right will be in the prompt. Maybe the law will change. I don't know. The progress will make the law change, and there will be something attached to the prompt rather than to the output. Because the argument against giving rights to the output is that you're not doing the magic. It's a black box that does. So it's not your creativity in the black box. Your creativity is at least only in the prompt. So, but we'll see. We have to
finish, unfortunately. But
can we have just the last? Yeah, we know.
Just some food for thought.
Yeah, exactly.
Because as I can hear my fellow attendees, we are circling around the idea that still the output might have a slim chance of being creative. And you've mentioned that some prompt engineers are very highly qualified and that they could create a very elaborate and detailed prompt. And what if we would seek analogy in a more traditional creative arts, for example, movie making or even video game creation? Because, when a director or a creative director works with, of course, mostly with humans, but there's also some element of unpredictability, because every take is also always different. And what if the specific prompt is a labor of hours, blood, sweat, and tears, and the prompt engineer is aware and is able to somehow predict the result? So I think that there is a slim chance, and of course, at the end of the day, it's always about litigation. We have to prove it. But I think that there is, as I've mentioned, a slim chance that you could prove that the creative process is within the input and how I created this input, every nook and cranny that is inside the prompt. So yeah, just to stir things up.
I tell you what, let's meet next year in this, with people on this in this room, and let's discuss. We'll see. Maybe we'll have an answer from the U.S. legislation or jurisdiction, and we'll see which way it goes. Thank you very much, and thank you for participating and for your questions. Thank you.
Thank you very much for such an interesting presentation.